Hey everyone, thank you for being here. Welcome to our AU member briefing for the Carson v. Makin Supreme Court case that was just decided yesterday. We're going to give it a few minutes because we have a lot of folks that have signed up and will be joining us this evening. So just sit back and relax, and we will get started in just a few moments. Again, thank you all so much for joining us tonight. We're just giving it a minute or two for everyone to have a chance to join. We have a lot of folks that have RSVP'd tonight because a very important case was just decided yesterday. We know you're all eager to hear about it from our panel of legal and policy experts. So thank you all so much for joining us tonight. And we look forward to getting started in just 1 or 2 minutes. All right, we're going to go ahead and get started and just do a little bit of introductions while the remaining of the folks are joining us. So again, welcome to our AU member webinar and briefing about the Carson v. Makin case that was decided yesterday at the United States Supreme Court. My name is Brian Silva. My pronouns are he, him, and I'm the Vice President of Outreach and Engagement here at Americans United. Just a couple of pieces of housekeeping before we go ahead and get started. I would like to introduce Mary, who is our ASL interpreter tonight. I'd also like to remind you that closed captioning has been enabled, so you should see that along the bottom of your screen. If not, you can click on the More button at the bottom of your screen. It's the 3 dots, and you should see the subtitle, which you can turn on and off if you're having trouble seeing it. But again, we do have ASL interpretation and closed captioning going on during the webinar. We know that many of you have come here because you have a lot of questions, and we want to answer as many as possible. To do that, we're going to be using the Q&A feature. So again, along the bottom of your Zoom screen where it says mute, stop video, and other buttons, there's also a button that says Q&A. And you can go ahead and type any questions that you have in there. We will answer those questions, as many as we can. We won't necessarily answer them in the order that you type them. We'll try to answer them at the best parts of the webinar, and then the rest we will save for the end as well. But feel free to put those in at any time. All right, so again, thank you and welcome again to Americans United's webinar briefing about this case. For those of you who might not be as familiar, Americans United is the only organization dedicated solely to defending the separation of church and state. We are the shield protecting the foundational American principle of freedom of religion, including the right to believe or not for everyone. And it is now my honor and pleasure to introduce our president and CEO, Rachel Lazar. Hey, Rachel.
Hey, thanks so much, Brian. And so nice to see everyone. Well, I can't really see you, but nice to know that you're with us. These are really trying times, and I think it's important to have the company of one another. I want to start by reading you a quote from Justice Sotomayor's dissent from the Carson v. Makin decision. She wrote, "What a difference 5 years makes. In 2017, I feared the court was leading us to a place where separation of church and state is a constitutional slogan, not a constitutional commitment. Today, the court leads us to a place where separation of church and state becomes a constitutional violation. What Justice Sotomayor was referring to is the fact that the court is now saying that keeping religion and government separate and allowing Maine not to fund religious education is a violation of the First Amendment. As Justice Breyer pointed out, the court is ignoring the Establishment Clause, allowing it to be totally overtaken by the Free Exercise Clause. We know that funding another religion's teaching of religion, not to mention in many cases bigotry towards your own belief system, including discrimination against LGBTQ people, is about as core a violation of religious freedom as we can think of. The truth is that the court's majority is gaslighting Americans. The only discrimination that they mention is the discrimination towards conservative Christian schools and not the discrimination of the religious schools involved in the case that is right before the justices. And those are terrible examples of discrimination. One of the schools won't hire LGBTQ teachers and won't admit students who are LGBTQ or students who have LGBTQ parents. And another of the schools expels students who won't renounce their LGBTQ identity and forces them to go to conversion therapy. That school also teaches in their 9th grade social study class against the Muslim religion, right? So in Maine now, taxpayers who are Muslim will be funding anti-Muslim bigotry. We have reached a point where religious extremists and their lawmaker allies' longtime crusade to win taxpayer funding for private religious education has reached a whole new high, and where the crumbling wall between church-state separation has reached a new low. Religious extremists are coming for our public schools, and that's something that I think you all understand, but that too few Americans do. It's an untold story of our current moment. And as you know, any day now, we're going to receive the opinion in our Kennedy v. Bremerton case about whether coercive prayer will once again be allowed in our public schools. But it's not just our public schools that religious extremists are coming for. It's also abortion rights, as we're also about to witness, very sadly, in the coming days of the term. It's LGBTQ equality. It's voting rights, because these religious extremists are some of the leaders in the voter suppression efforts. And it's also racial justice, because what we see in the amicus briefs and in the opposition that we're constantly dealing with is that the same people who are opposing Roe v. Wade are supporting school vouchers for religious schools, are trying to insert prayer into our public schools, are pushing the Don't Say Gay bills, are crying out against critical race theory, and are asking for religious exemptions from non-discrimination laws. They are trying to force everyone else to live by their beliefs and to use religion as a license to harm others and to discriminate. And we also know what their ultimate prize is. It's the takedown of our democracy, which January 6th made so clear. That's all pretty grim. And I know I say this a lot, but I'll say it again. They are on the losing side of history and of America. 2/3 of Americans, as we saw in our recent polling, support the separation of church and state. It's just this ultra-conservative court and the far-right Christian nationalists that are attacking this fundamentalist principle. They are gasping for air because they're seeing the demographic changes in our country, the first Black president that we had recently, the advent of marriage equality and the increase in LGBTQ rights, the Me Too movement and the unprecedented number of women in Congress. The list is long, right? The movement for Black lives, everything that they see, they are fighting against, they are grasping for air. And we know that if we play the long game, that we will win. We are certainly going to keep fighting with you on our side, and we will not give up hope. We've been at this for 75 proud years, and we've got at least another good 75 in us. And that's why the work of Americans United is so important. As you know, we are the only national nonprofit that works 24/7, right, to fight Christian nationalists. We're the only secular national nonprofit that are doing this work and to keep religion and government separate. We are a watchdog. We are the watchdog, and we will continue to fight. So what are we going to do, right? The million-dollar question. Well, for one, we know that we must continue to oppose all vouchers. If the court is going to insist that any money that goes to private schools has to also go to private religious schools, and in this decision, it went from may to must, we know that we have to oppose all private school vouchers. They take critical funds away from public schools. And if you go back to our founding manifesto 75 years ago, we are public school proud from our roots. We understand that public schools are very important to protect the fundamentals of our democracy, including church-state separation and the pluralism in our country. But we also know that at Americans United, and as part of this movement that you're all part of, that we need to reach the next generation of leaders, right? And we've actually started a next generation fund at Americans United. We are doing this work very intentionally today. We have our essay contest, which we love, and we are doubling our submissions for now from teenagers, but we're also taking applications for our third class of youth organizing fellows. Those are stellar, amazing young people that are leaders in their own right, learning skills from us and bringing them out to a new generation of leaders, right? And we know that we need to play the long game. The Federalist Society hit 40 years this year, and that's okay, right? We've been around for 75, but we started a legal academy this year to fight back, right? And to train a new generation of lawyers in how to fight for the rights of the people and networking them with each other and with our generation. Something else that we know that we need is a national recommitment to church-state separation. How does that sound? I wish we could unmute you all, because I bet you'd be. We know that we need it, and we're going to design it, and you all are going to be part of it. And it's just time to make sure that we are illuminating for our entire nation the critical role that you all know that church-state separation plays for so many of the rights that we care about, for freedom without favor and for equality without exception, as our new tagline goes. So with that said, I will turn you over to the brilliant hands of our wonderful panel of Maggie and Alex, and back to you, Brian.
Thanks so much, Rachel. We are super excited to have a great panel for you tonight. It's my pleasure to introduce my colleagues, Maggie Garrett, who's our Vice President of Policy here at Americans United, and Alex Bodakin, the Stephen Gay Constitutional Litigation Fellow here at our legal department at AU as well. Good evening. Thanks for being here.
Thanks, Brian. Good evening.
Yeah. So Maggie, let's go ahead and start off with you. And just let's get an understanding of the facts of the case. So Maine has a really unusual system. Can you give folks a sense of how that system works and what the Institute for Justice, who are the lawyers on the other side, what were they arguing?
Sure. So there are some areas of Maine, the state of Maine, that are too rural to maintain traditional public schools. So in order to meet its obligation to provide a public education in these areas, Maine has a program that offers public education through either neighboring public schools or nearby private schools. This program was never meant to be a private school voucher that gave money to students to attend any school that the parent chose. Rather, the state was viewed the program as contracting with private schools to provide a public education because the state itself couldn't in those limited areas. Because the state was providing a public education, the state would only fund secular education, not religious education. According to the rules of the program, religious private schools were eligible to participate in the program so long as they taught a secular curriculum and abided by non-discrimination laws, just like public schools. Of course, public schools are secular for a few reasons. because it protects the religious freedom of taxpayers. The government should never force taxpayers to fund religious education. And also because keeping our schools neutral on matters of religion ensures that all students and families are welcomed and treated equally, regardless of what the religious beliefs are, and if they don't practice any religion at all. So the Institute for Justice claimed that since the state funded secular education at private schools, the state was then obligated by the free exercise clause to fund religious education at private schools too. In fact, they claim the state's refusal to fund religious education was actually religious discrimination, as Rachel alluded to. So it was religious discrimination against those schools and the students who wanted to attend them. AU clearly opposed that position. Maine denied tuition money to religious schools, not simply because they're religious, but because they'll use it to promote religious education and views, which we argued violates the Establishment Clause. We also pointed out the hypocrisy of claiming that Maine was discriminating against religion when the schools themselves that the plaintiffs wanted to attend with taxpayer money actually discriminated in admission and hiring against non-Christians and LGBTQ students, parents, and teachers.
Well, that is a mouthful.
Does that make sense?
Yeah, no, there's so many things that went into this case. It's been interesting to me to see this case as kind of running under the radar, I feel, a little bit for folks who weren't. And then when the decision came out, because of the way it was written, which was so just mind-blowingly crazy, I felt like everybody all of a sudden was like, wait, what is this case? And so, Alex, in sort of that vein, the idea that a state must fund religious education at private schools, emphasizing, folks, the word must, if it's funding public secular education at private schools, it does sound pretty outrageous. Can you tell us what the Supreme Court has previously said about the government funding of religious schools? Was their argument like a big leap in a different direction?
Yeah, thanks, Brian. I think it was, although as the court really tried to portray it as not much of a big leap. And it's true that, religious extremists have been laying the groundwork for this for quite a while. But even though the court tried to sort of portray it as just another small step, I think, as you said, the emphasis on the word must shows that it was a big leap. I think just to talk quickly about some of the decisions that led up to this case, and what the court has previously said about funding religious activities and religious education in particular. In general, the Establishment Clause prohibits the government from either preferring one religion over another or preferring religion over non-religion. But cases arise where the government has a general funding program. So, for example, like Maine's tuition assistance program, of how the government should treat religious entities or institutions that apply for that funding. So one rule would be that governments shouldn't fund those entities and institutions because that would represent taxpayer money going to religious use, religious institutions, and that violates the Establishment Clause, the Constitution's prohibition on the governmental establishment of religion. Another view is the opposite, that the government must fund religious entities because not to do so would discriminate against religious entities, violate the free exercise clause of the Constitution. As Maggie said, that was the Institute for Justice's argument in this case. There's also sort of a third middle ground that a government is allowed to, it's permitted to fund religious institutions if it wants, but it's not required to do so. Now, look, as a church-state separation organization in all the ways that Rachel and talked about at the top, our longtime organizational position has been that the first option is the right one, that taxpayer money should not flow to religious institutions because, as James Madison put it, this is a very old idea, right? Even forcing a taxpayer to contribute 3 pence of tax dollars to religious institutions constitutes improper government endorsement and endorsement of establishment of religion. And at one time, the Supreme Court held that view, which really is the view of the founding generation. That was true in the 20th century. Around the turn of the century, the court shifted a bit and it began to adopt what I described earlier as the middle view, that states are allowed to include religious entities in generally available funding programs, but they aren't required to do so. So 2 quick cases. 2002, a case called Zellman against Simmons-Harris, the court said 5-4 that Ohio, the state of Ohio, was permitted to include religious schools in its school voucher program, but nobody thought and I mean nobody, thought that Ohio was required to do so. The only argument was whether they were allowed to do so, and the court narrowly said yes. 2 years later, a 2004 case called Locke v. Davey, court held 7-2, an opinion written by then Chief Justice William Rehnquist, extremely conservative, that the state of Washington was permitted to exclude money in a scholarship program from going to the pursuit of theology degrees. Same rationale, right? A different state could allow it, but the state of Washington didn't have to. And so that's sort of what the state of the law was until very recently, that states were permitted to fund religious institutions through generally available funding programs. They weren't required to do so. But Brian, I know you're going to follow up with Maggie a little bit about some of the more recent cases and how this newly constituted court has really wrought a revolution in this area.
Yeah. Just as a quick reminder for folks, if you do have any questions along the bottom of your screen, you can click the Q&A button. That's where we'll be pulling questions from. Unfortunately, we can't pull them from the chat box. So just a reminder for that. So Maggie, so that was the rule from a different era of the court. The states were allowed, but not required, to fund religious activities when they created a grant program. So could you talk a little bit about the more recent decisions that started to chip away at that idea?
Yeah, sure. So there's two pretty recent cases that set us up for where we are today. Both as written seemed pretty narrow, but they actually are what allowed the court to have this radical decision in Carson. So the first case is the case Trinity Lutheran. In this case, you might all remember because it was just in 2017. Missouri had a program that provided grants to schools and nonprofits to resurface their playgrounds to make them safer for kids. In order to uphold church-state separation, only secular entities were eligible for the grant. And this was not an uncommon practice to ensure that taxpayers weren't forced to fund religious entities. But the Supreme Court held the state was discriminating against religious entities, right? So this is where it's a drastic departure. Suddenly, it said that denying religious groups a benefit like playground material solely because the entity was religious, their status was religious, violated the free exercise. This was unprecedented as a legal theory, that allowing free exercise clause rights the free exercise clause swallowed up the establishment clause. And so the court forced Mississippi to provide grants to the religious schools and nonprofits. But they said they weren't addressing whether or not you could use the money in a religious way. So, and then in Espinoza versus Montana Department of Revenue, which is just 2 years old, the court took up the issue of private school vouchers. So really close to what we are having here. Montana funded vouchers at secular schools, but not at religious schools. Again, similar to what we have here. And parents wanted to use the money at religious schools, claiming religious discrimination. Of course, tuition is different than a playground material, which can't be used for like a religious use. And so the issue of use we thought was going to come up in Espinoza, but the court dodged the issue again. They ignored the fact that religious school vouchers, or that school vouchers at religious schools would fund religion. And they said, no, again, you're just ruling out all religious schools. You're not looking to see what they teach. You're just saying no religious schools. And so that's religious status discrimination. And again, they saved the issue of religious use again. So in short, Trinity and Espinoza stand for the proposition that governments can't prohibit religious entities from participating in funding programs because of their status. And so, but said, maybe you can limit their use of the funds.
So we have a lot of questions about the actual decision of what the court said. So I'm going to consolidate some of them because a lot of them are asking the same thing, which is great, showing us a lot of interest. But before we get to that, let's give folks, Alex, the basics. What did the court say in this decision of Carson v. Makin?
Yeah, so put simply, Brian, it threw out that distinction that Maggie just talked about between status and use-based funding limitations. According to the court, any school voucher program that includes non-religious schools must include religious schools as well. And here's the big jump, it has to include that school even if the school will put the money to religious use through religious instruction. And as to paraphrase our current president and former vice president, this is a big effing deal. The court has never before said that the state must fund religious education, or more generally, that state must provide funding for religious uses. Remember that case out of Washington, Locke v. Davey, it had said the opposite, that the Washington state wasn't obligated to fund degrees in theology, but now Maine, if it keeps its voucher program, will have to fund religious education.
So we've gotten a couple of questions about now that that these private religious schools can receive public funds. Was there anything in the decision that also said that they now have to follow the same standards of public school education, or any of the same policies that other schools that receive public funds, public schools have to follow?
I can speak
And
to
I'll put that, yeah, I'll put that out to either of you, sorry.
And Maggie, you should correct me if I get any of this wrong. I mean, so Brian, so they do have to follow some standards. Basically, the way that the system operates in Maine is that public schools have to follow one set of standards, and then private schools have to follow a different set of standards that are standards, but they're not quite equivalent. But what the court focused on was that even the private religious schools did have to follow at least some set of standards. And so in its view, there was no justifiable reason to withhold funding from those schools. Now, in a different state, if private religious schools didn't have to follow standards, certainly I think that would be a persuasive argument. The court didn't find it persuasive here. But Maggie, if I got anything wrong about that, you should correct me.
No, I think that's right. I think that they will still be able to put curriculum standards and things like that. Justice Roberts spent a lot of time talking about how few requirements were on the private schools. And that's why he was like, you know, if they're really different, right? If you don't have all these requirements in the private schools, how can you then just be like, oh, well, being secular is a really important one. But they didn't unwind any of the requirements on there. And, you know, another, not to like jump in, Brian, but another question I'm seeing from a lot of people is like, well, what can Maine do now? And do you have to fund private school vouchers now, or do you not have to? You don't have to fund private school vouchers. What Maine could do, and Justice Roberts set out explicitly, is, you know, they could just decide to fund public schools only. And if they wanted to do that, then they wouldn't have to fund private schools at all. I just want them also to know, I think there was a question about this, is AU does oppose all private school vouchers. We do not just oppose private school vouchers that go to religious schools. And in part, you can't really have a private school voucher program without it going to private religious schools, because they are cheaper usually than the secular counterparts, because they're subsidized by the church. And so really most voucher programs can't work without religious school participation.
Well, and now just to add to that, now I think it's literally unconstitutional post Carson to have a voucher program without religious school participation. So just to echo Maggie's point.
And just to cap on that before I move to the next question, a couple of folks asked about, does this force them to fund homeschooling, or does this have any effect on homeschooling, or do we not know that yet? And that's okay to say as well.
I think that's an interesting question. I think homeschooling is different than funding private religious schools. You know, if they start, and you know, in that case, right, I feel like homeschooling doesn't have a lot of restrictions on it. And so if they were probably, there have been calls for funding homeschool through tuition tax credits, and which I think there might be one that has passed, but I think that they probably wouldn't be able to say that you're not allowed to teach your kids religion at home if you're allowed to teach them something different.
Well, you know, one of the things, and kind of part of the reason why AU opposes all, you know, private school vouchers, and one of the things that's great about public schools is that they are for the public. They accept everyone, and they have to accept everyone, regardless of your faith, regardless of your sexual orientation, regardless of disability, regardless of race, all of these things, of which, you know, private schools can pick and choose who they want in there, which is a big problem with private schools and hence vouchers. So Alex, one of the real troubling parts of this case is that the plaintiffs wanted to use these taxpayer dollars to send their kids to schools that, not under the radar, but officially in policy, discriminate against non-Christians and LGBTQ+ families and parents. This just makes it an even more important decision during this Pride Month. So during oral arguments, this is something that the state of Maine seemed to want to talk about, but the Institute of Justice tried to avoid. So tell us whether the court addressed this and what did they say?
You know, it's maybe not haha funny, but it's funny how the decisions really echoed what you just described, Brian, because the majority opinion didn't want to address this issue, whereas the dissents certainly talked about it. You know, the court only addressed the idea of the discrimination that many religious schools, including the schools in this litigation, have in a footnote. And what the courts really did was it tried to dodge the issue. It said that while it was ruling that Maine could not exclude a school from funding just because the school uses the funds for religious instruction, it wasn't reaching the issue of whether Maine could deny funding to any specific religious school based on that specific school's discriminatory practices. And Rachel talked about, and Brian, you just mentioned many of the practices that these schools had. They discriminate against LGBTQ kids, against LGBTQ parents. One of the schools in this litigation taught a curriculum that really was Islamophobic. Because the court didn't address whether these specific schools were entitled to get funding, but rather just invalidated Maine's blanket prohibition on religious schools getting funding through the program. If Maine chooses to retain this program, this tuition assistance program, it might attempt to argue that the specific discriminatory practices of individual schools give the state the right to exclude those specific schools under Maine's anti-discrimination laws, which do protect against religious discrimination. They protect against discrimination based on sexual orientation and gender identity as well. It's hard to predict the outcome of that litigation. The religious schools will certainly then say, no, we have a religious right to exclude those people. This is the kind of litigation that we deal with at AU all the time, and we'll be watching it closely. You know, I think the bottom line on all this is that taxpayers should never be required to fund discrimination. The ruling in Carson makes it significantly more likely that they're going to have to do so at least some schools, even though there's really no constitutional basis for the court's holding. And that's, you know, hugely disappointing, and it raises a host of problems that don't need to be raised, regardless of the outcome of future litigation.
Thanks, Alex. And I do want to thank the folks whose questions we've got to answer. Carrie, Susan, Kenneth, John, Jason, Alan, Carol, we appreciate it. We've got a lot of questions. We're going to keep going to them. One question that folks want to talk about is other states and how this affects other states. So Maggie, at the start of our discussion, you said that the Maine program was pretty unique. So does that mean that this case is limited to the Maine program, or will this have an impact on school voucher programs too? So like, I guess in other words, what will be the real life consequences of this case on our education system, and maybe also, you know, just different states in general? And Alex, feel free to add on as well.
Yeah, the decision is not limited to Maine's unique program. The court rejected Maine's claim that it was funding public school education through private schools and really treated this as it would any private school voucher program. So I think this does apply to all the states, the federal government, anyone who wants to create a voucher program. And essentially the decision says once the state decides to create a voucher program, it must allow religious schools to get vouchers, even if the religious schools only provide religious instruction. Of course, the decision doesn't require, again, it doesn't require states to create a voucher program in the first place. And so the smartest move is to just keep your money in public schools. And we hope that this decision will actually inspire more people to oppose new voucher programs and roll back existing ones.
The only thing I would add to Maggie's discussion of what this means in the school context is that, you know, we know that the religious extremists on the other side of this are going to try and use this decision in other contexts as well. The idea that anytime you fund any kind of non-religious program, you have to provide some funding or equal funding for the religious equivalent. That reasoning is not necessarily limited to schools, right? So you can imagine people arguing that, for example, faith-based drug treatment facilities are entitled to funding on equal footing with non-faith-based drug treatment facilities. And there's a whole host of other issue areas in which we know that the folks on the other side of these issues are going to try and take this reasoning. And so even though this decision was on education, we know we're going to be fighting battles on a lot of fronts.
And Brian, can I just add in there too about vouchers that I think we also need to be really careful. You know, you might be thinking, well, you know, all these states have money's going to religious schools through vouchers anyway. But I just want to point to the momentum that was created after Espinoza, the last voucher case, which, you know, in some ways you could say, you know, the programs already existed. Espinoza, the momentum there led to the passage of 22 state voucher bills the following year. 7 bills created new programs and 15 expanded existing programs. In 2022, we had 6 more bills that were passed to expand vouchers. And so we have to really be careful about that. And another thing, I expect them to try to push back on the non-discrimination protection. So Alex talked a little bit about non-discrimination protections and how they ignored that piece. I expect that the Betsy DeVos's of the world, the anti-public school forces, the pro-voucher people are going to say that this case means that they can't have non-discrimination provisions, and they're going to try to roll them back, which means that we have to push even harder to prevent that. And we have to push even harder to not allow new voucher programs to exist.
So a couple of follow-up questions for vouchers. I'm going to try to keep them short so we can jump into the rest of the questions. Susan was asking about vouchers with kids for disabilities. Wouldn't that be helpful?
Good question. I have an answer for that.
Yeah, go for it. So
actually, vouchers don't help kids with disabilities. I know it sounds like it would. So if you have a student in a public school and the public school determines that they are not able to serve your child at that school, you can do what's called, the school will place you in a private school if that's what happens, and they pay for everything. You keep the protections. That's not considered a voucher. That is considered the school placing you if the public school can't serve you. What happens with vouchers, and this is why the ARC, Easter Seals, a lot of disability groups oppose private school vouchers, is because when you go to those schools, you, one, lose all of your rights under IDEA, which is what protects kids with disabilities in schools. And the schools aren't regulated in any way. So like the program in Florida, like the teachers don't have to be actually taught or have any standards that they can actually teach students with disabilities. The schools don't have to prove that they can provide the services. And so you actually end up losing a lot of rights. It's sort of like actually, and you push them to a school that doesn't have to serve them rather than keep them in the public school that has actual laws that have to serve them. So that's a good question, because there are a lot of school vouchers for kids with disabilities.
And just to ask, you know, for folks who might not be as familiar with vouchers, and there are a couple of different types of programs. I'm going to see if I can put my Maggie and policy hat shop on here and say that the general idea of a voucher is you get a certain amount of money to then go to the school of your choice. That's kind of how it's sold. But many of those schools have no standards of curriculum. They're vastly more expensive than the voucher, so you can't even use them to go there anyway. Is that kind of some of the key things that we're not particularly fond of about vouchers in private schools? Yes. I could add a few more to your list if you wanted. Sure, give us 1 or 2 more. So study after study shows they don't actually improve educational outcomes. They lack accountability. They discriminate against students. Some of them, they don't have to be accredited. You might have just mentioned this, but like in Florida, for example, the private schools that take vouchers don't actually have to be accredited. So there's a series of kids who graduate from high school with a voucher in Florida, and they can't go to college or university because they didn't actually go to an accredited school. So I'll leave it there. I could go on for hours, Brian. No, I know. Alex, a couple of folks, Dean, one person asked what we can do differently at the Supreme Court. Others have asked, is it too dangerous now to bring cases to this type of Supreme Court? You know, how does this affect how groups like AU and others are going to, you know, handle a court that is ignoring precedent, redefining the definition of words, saying things like, let's ignore the facts for a moment and talk about whatever we want, like in the Bremerton case. Talk a little bit about what we do differently at the Supreme Court, or what groups in general can be doing.
Yeah, thanks, Brian. You know, we think every day, all the time, about legal strategy here at AU and what kinds of cases and what kinds of cases to bring and what kinds of courts make sense to bring them in. With the backdrop being a Supreme Court that is extraordinarily hostile to our issue area, to the separation of church and state. You know, sometimes we aren't given a choice. This case is an example, as is the Kennedy case, because in both of these cases, the lower courts reached the right decision. And then, you know, those decisions are appealed to the Supreme Court. You know, Maine had its program. The program was challenged. It successfully defended its program before the lower courts. And the parents appealed and got to the Supreme Court. The Kennedy case is very similar, where the lower courts, and that's the praying football coach case, for those of you who are maybe less familiar with it, but the lower courts upheld what the school district did repeatedly. But again, the folks on the other side kept appealing and got in front of the Supreme Court. And so, you know, in those cases, there's not a lot you can do to keep it out of the Supreme Court. Certainly, where we can, we're trying to bring cases in state courts, in trying to bring types of cases that we think would have more success in the Supreme Court if it got there, if we do bring it in federal court. You know, and I think we're always trying to think about ways to appeal to the median justices, which, as the court has moved rightward, the median justices have moved rightward. But that means appeals to history. Our brief in this case, our amicus brief in Carson, focused an enormous amount on the history of state constitutional provisions that were the backbone of the federal First Amendment, many of which prohibited funding for religious education. Not just me, but our team here at AU did a ton of research, and that's the kind of, you know, originalist thinking that we were hoping would appeal to the Supreme Court. It's tough to sit in the, you know, background of a loss and think about what you could have done differently, but those are the kind of things we're going to continue to try and do.
Thanks. And Maggie, just to kind of piggyback off of that, are there things that states, like that Maine specifically, but or other states can do at this point, or that we think that states can do to try to preserve, you know, after this decision, public education, you know, and separation of church and state at the state level? And I'll lead into another question that a few folks here have asked about no aid clauses in state constitutions.
So, I mean, it really is about opposing vouchers and rolling back voucher programs. There are some ideas of, can you add, you know, accountability protections to them? Can you add non-discrimination protections to them? I know that there's a Georgia tuition tax credit that, you know, they have that provision. I'm always wary about trying to make a voucher bill better when fundamentally it is bad policy, right? So it's really hard to make it better. I still think that we are at the spot, especially after this case, where what it means and the opening for non-discrimination and the fact that they are teaching religious curriculum. I don't know how you save that, right? With some of the curriculum standards that they put in there. Could they try something where they have curriculum standards that are equal across the board? Maybe. But I think our best bet is to just recommit to our public schools. We don't need voucher programs. They don't work anyway. And we should be creating, you know, if you fault our public schools, they're not perfect, but we should be working on making them better so that every student has the ability to go to a good school and have a good public education, rather than diverting money to private schools for a few students. And that's not fixing the public schools. It's just making them worse by taking away their money.
So a couple of folks have asked about what's called no aid clauses in state constitutions, which quite a few states have. So before I kind of dig into that, or even just let you say, you know, how this might affect that, folks are kind of wondering if that effectively strikes those clauses down. Can you give folks the 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 simple version of what a no aid clause is first, and then how this ruling may affect those going forward. And Maggie or Alex, either of you or both of you.
Alex, do you want it?
Sure, although I may be a little cagey in the second part of the answer, Brian, so I apologize in advance.
Cage away, my friend. That's all right. That is all right.
Well, I apologize to those listening. So a no aid clause, many state constitutions have clauses that explicitly prohibit taxpayer money from going to religious institutions. So that's sort of the simple definition of a no aid clause in state constitutions. And these are longstanding provisions. Many of them, most of them were enacted in the 1800s. So there's a long historical tradition of them. As Brian mentioned, I think it's 37 states, maybe 36 that have them. This decision does call into question, I think it's fair to say, the constitutionality of at least some of them. But because AU is involved in active litigation defending several state no aid clauses, and because we're still reading the Carson decision very carefully to see exactly what it says and doesn't say about the constitutionality of those and how it will apply, I don't want to say anything on this webinar that could possibly jeopardize our litigation positions in those cases. So that's me being very cagey. I certainly, it's something we have to consider. And that I expect, I think it's safe to say that I expect the folks on the other side to try and use in that litigation. But I don't want to say too much more than that.
Maggie, did you have anything you wanted to add, or?
Well, after that second part, I'm going to keep my mouth shut.
All right. All right. Another group of questions, I just want to say we have answered 26 questions from folks that we've been able to interject or compile. So we thank you to keep those all coming. And we're going to still keep trying to answer as many as we can in the last 15 minutes. So one of the questions that keeps popping up is the First Amendment and freedom of religion. There's two parts to it. There's the free exercise clause and there's the establishment clause. So before we dive into kind of the group of questions that's about, would one of you just like to give folks just a simple kind of explanation of what those two parts are and how they're supposed to work together in the Constitution?
I can take that, certainly. So it is the very beginning of the First Amendment. I may not get the wording exactly right. I don't have it pulled up, but the First Amendment says that Congress shall make no law respecting an establishment of religion. So that's the Establishment Clause, or prohibiting the free exercise thereof. So that's the Free Exercise Clause. And the way that those two provisions are supposed to work, and the way that they did work for quite a while in terms of how the Supreme Court interpreted them, was that the Establishment Clause forbid any kind of government endorsement or furtherance of religion. It forbid any preference of religion over non-religion or of any certain religion over others. Whereas the Free Exercise Clause protected the exercise of religion so long as the exercise of that religion didn't harm others and didn't lead to an establishment of religion. In other words, the Free Exercise Clause, would have expanded to the point where the Establishment Clause constrained it. That is how the two clauses, really are meant to be interpreted and how they were interpreted for quite a while.
So with those two that are supposed to be working in harmony and have, for the most part of our country's history, we have a couple folks, Joel being one of them. When the court has been asked to address the meaning of the Establishment Clause, how have they rationalized it? Are they just, does it feel like this is just ignoring its existence? Like, have they just started to basically only look at one size? Richard asked, with them emphasizing the Free Exercise Clause, and we'll bring Rachel in a minute, talk about how that might affect the abortion issue. What is the court in this decision saying about those two halves of what used to be a kind of harmonious part of the First Amendment?
I mean, Alex, you might have dug more into the case than I. I feel like I needed to read it a few more times, but I feel like they just ignore it. They're not interested in it. They don't really give a justification of, well, the Establishment Clause means this and the free exercise means this, and the free exercise clause wins. They essentially kind of say, well, there's really no compelling interest in, preventing the establishment of religion, and therefore the free exercise clause always wins. They haven't created, so far as I can tell, in this line of cases we talked about, a new test for the Establishment Clause. They just kind of say, the free exercise clause wins.
Yeah, I don't have much to add to that, and I don't think you need to reread the case, Maggie, because that's accurate. And by ignoring the Establishment Clause, as Maggie says, it essentially writes it out of the Constitution, because if you just don't talk about it and it never has any weight in these cases, then it's not doing any work.
And I think one of the things that was interesting to me that I've always read is that, especially those of one oftentimes political persuasion, love to talk about, the free exercise clause. Everybody should be able to, to practice their faith however they want. But the question is, free exercise of whose religious belief, and as we have seen what this court and many others, it feels like are very much interpreting that to mean the free exercise of a very narrow, specific religious belief, or group with a specific religious belief. And what happens when those, come into, into conflict? And so in moving into that question, I'm going to bring Rachel back on. Rachel, are you here? There we go. Oh, you're muted, which is the second most popular thing to say on Zoom, I think. So, oh. You're still muted. That's the first most popular thing to say.
Sorry. Hi.
That's okay. So I'll let you just start off, if you anything else you want to say about, this topic of the exercise versus establishment, but then lead it into a couple of folks specifically went into the question about abortion. And I know you have a long history in the reproductive freedom movement. There's been some court cases potentially coming forward, different religions, and I think we're becoming more aware of this. Different religious beliefs have very different views on abortion and religious freedom. So if there's anything you want to add to the first part of it, and then if you want to address how this might affect abortion and religious reproductive freedom.
Sure. So much to say. First of all, I will quote one of my role models in life, Justice Ruth Bader Ginsburg, who often wrote in her dissents, "Your right to swing your fist ends at the tip of the other guy's nose." And I'm using that quote because it illustrates the interplay between the free exercise clause and the Establishment Clause, which was often a context in which she was using it, which is to say, great, free exercise of religion is great, and we all want it to be there. It's a critical part of religious freedom, but your right to exercise your religion ends when it interferes with the other person's right to exercise theirs. So that's what I wanted to add on the interplay between the free exercise clause and the Establishment Clause. And it really shows the way the two work together, the Establishment Clause and the free exercise clause, to protect everybody's religious freedom. And I think in particular, religious minorities, those who are more disempowered, in our society, protects everybody's right to live and believe as we choose. Let's talk about abortion. So we all are expecting, according to the leak, that an opinion could come down tomorrow. It could come down Friday, which is a day that the Supreme Court added to their opinion day list this week, or it will come down next week, which will, we think, very sadly overrule Roe v. Wade and the fundamental right to an abortion. That decision was rooted in what the court found in Roe v. Wade and called the penumbra of privacy in our Constitution. People have often asked, why isn't this a religious freedom issue? Why hasn't the court ruled on religious freedom and abortion? Because it is a religious freedom issue. And I think one answer is the court didn't need to, because once the court found that the right to an abortion existed under the penumbra of privacy in the Constitution, that was enough. There was a constitutional right, and the court didn't need to reach what other parts of the Constitution might possibly bestow that right upon pregnant people. Now we are living in an alternate universe where religious extremists have succeeded in putting their star lineup on the Supreme Court. And, we are unfortunately and very sadly expecting the reversal of Roe v. Wade. Someone, Richard, in the questions referenced Rabbi Barry Silver's lawsuit in Florida, which challenges the abortion ban on the grounds of religious freedom, right? Good idea. So yes, I think that's a very good idea. We actually spoke with Rabbi Barry Silver this morning with our litigation team, and we want to be very helpful. The thing is, I think this crowd understands intuitively that abortion bans are rooted in one narrow religious viewpoint that's being imposed on the rest of us, even through our secular democracy. And I think it's in our Dobbs brief, Dobbs is the case that we're expecting will reverse Roe v. Wade, where we cite all of these governmental leaders who are involved in these abortion bans, who, say what they're not supposed to say. They say the secret. They attribute those bans to religious motivations, right? We cite them. And I think because not everybody lives their life, knows that abortion is available, seeks an abortion with their religious framework necessarily in that moment in their mind, it might not seem to many of us living our lives that our right to seek an abortion is a religious freedom right. But I think it's easier to feel the attack on our religious freedom when a narrow religious viewpoint is being adopted, by our secular democracy and imposed on all of us. And I know how clear that is to me as a Jewish woman, right? Because in Judaism, we are required actually to have an abortion if our lives are at risk. And I used to work for the Reform Jewish movement, where there are many resolutions from our movement that support abortion rights as part of the Reform movement's religious beliefs. So is there a good argument against abortion bans under religious freedom? Absolutely. It is harder because religious extremists have gotten smarter and they have scrubbed their religion language from almost all of their abortion bans and regulations for the reason that it's unconstitutional. So again, part of this alternate universe that we are living in. But is it appropriate right now to bring some challenges to these abortion bans under religious freedom? Absolutely, because at a minimum, it will appropriately reclaim religious freedom as something that belongs to all of us and not just conservative Christians in this country. And muddying those waters and dishing back to religious extremists a dose of their own medicine, which is seeking religious exemptions to everything, right, as religious privilege. Muddying the waters and using their strategy is something that we've been cautious about in the past, because we don't like how often religious freedom is misused to license harm to others. But in this moment that we're living in, it feels appropriate to use religious freedom and to demonstrate that it belongs to all of us, and that things like abortion bans are efforts to impose one set of religious beliefs on the rest of us, and that is unconstitutional. So we are looking into our own options as well and expect more news and more activity from us on that front. Sorry, that took a really long time. We're at 8:29, and back to you, Brian.
Great. I'm going to turn it over to Alex and Maggie for their final thoughts before I wrap up.
You're muted, Maggie.
Sorry, I had a car go by, so I had to mute myself. So as my last thought, I just want to point out that this case is part of an ongoing attack on public schools. Anti-public school forces are creating false controversies in our public schools. The architect of the anti-CRT movement has admitted his goal is to create distrust in the public school system so we can push for school vouchers. After the Carson decision yesterday, he was commenting online that it was time for universal school choice. Anti-mask advocates, those pushing the Don't Say Gay bills, and those supporting Coach Kennedy in the case we argued in April are all saying that moving away from public schools and funding school vouchers is the real solution. Vouchers are even being pushed. This happened in a congressional hearing. They're even being pushed by the Heritage Foundation as a solution to the horrific tragedy of school shootings. Of course, private school vouchers aren't a new way to undermine civil rights. Private school vouchers were created after Brown versus Board of Education as a way to fight the desegregation of public schools in the South. Using the language of parental and educational choice, vouchers were designed to funnel money from public schools to white segregationist academies in the South. The legacy of dismantling public education in favor of a system designed to benefit and uphold white Christian nationalism continues in the wake of this decision.
I know we're at 8:30, so I'll just close by echoing what Rachel started with, which is that we need a renewed commitment to really rebuilding the wall of church-state separation. I just wanted to say a sincere thank you for all of you to being a part of that movement. We feel it and we appreciate it.
Thank you both, and thank you, Rachel. So the last thing to wrap up is, folks are asking what we can do, and there's some short and long-term things that we can do. So I'm just going to quickly share my screen right here. So hopefully all of you are already signed up for AU's emails, which you can do here on our homepage at the bottom. Follow us on social media at Americans United on Twitter, Facebook, Instagram, and TikTok. That's where we're posting breaking news. That's where we're sharing information. So it's a great place to stay in the know when things are happening. This work is not cheap. We are up against $1 billion shadow network of DeVosses and Pences who are fighting every day to strip away the real religious freedom of our country, the right to believe as you choose or not, as long as it doesn't harm anybody else. And I'm going to make a special plug, if you're a donor, to consider increasing your donation. If you're not a donor, consider becoming a monthly donor, even if it's $5 a month. Really, every little bit helps. So please consider donating to AU. And the last two pieces, we'll be doing another one of these briefings the day after our other case at the Supreme Court, Kennedy v. Bremerton School District, goes down. We'll send all of these links to you along with a link to the recording at the end of this. And finally, join us on the day that the Supreme Court decides the decision in Dobbs, which unfortunately we do believe is going to be a very bad decision and repeal or potentially repeal the full right for women to have an abortion. And on that day at 5 p.m., people will be taking to the streets and rallying in cities and towns across the country. And we'll be sending a link where you can sign up to find a local event in your area. Again, I want to thank Alex, Maggie, Rachel, Mary, our ASL interpreter. My name is Brian Silva, again with AU. Thank you so much for being with us. Thank you for being with us outside of these. Thank you for your support. We cannot do this without you. Onward together. Good night.